would be, well, any subsequent objection by Mr. Deschler, who said just earlier that he's representing the city, including the city council, any objection to these exhibits at this point has been waived, because I gave him an opportunity, both at the time that I submitted them, at the real time at the time of the hearing, no objection was raised, and then subsequent, I followed with this letter, which is Exhibit 20, to here are all the exhibits that I presented at the city council meeting on December 4th, make it a part of the permanent record, and nothing further was heard. So it would be my legal position, if you're gonna object, or let me know, or at least let me know before the December 18th vote, the second city council meeting, so I can make a further record at that point in time.
What's your authority for that?
The authority would be, there's a whole line of case law as far as waiving objections.
Yeah, but that's at a formal proceeding. We're talking about a letter. I send you a letter and say, hey, I'm going on vacation to the Bahamas. I'm not going to be there. That doesn't mean that, you can't still raise an objection about that.
Yeah. I would say, okay, come on. You've been given multiple opportunities to raise objections to these exhibits. You were given one opportunity at the time of the hearing. You were given a second opportunity when this letter was sent. Okay, now here we are up on appeal, and for the first time we're gonna hear an objection to those exhibits. And what's your basis? Moreover, no matter what the content of these exhibits are, I think it's important for you to have the complete record, to have all of the evidence, all of the letters, all of the memos that are in that notebook that was before City Council when they made the vote. And you, as the zoning hearing board, have, like I said, wide discretion to give this evidence the weight that you feel it deserves. I would submit that you let it in and you look at it and then you decide the weight of that evidence. The important thing is not to exclude or cherry pick things out, that items that were before the zoning, that were before City Council making their consideration. My position is, I think it makes most sense to submit the transcripts, submit all the exhibits that were before City Council, and then give it that evidence its appropriate weight.
This pertains, though, to the exhibits, not the transcripts. In other words, in theory, could the board rule it won't take the transcript, but it takes the underlying? You're talking two different things, right?
They're blended because there's references in the transcript to all of these exhibits, and it makes the transcript obviously reads and makes much more sense when, okay, Darlene Heller is talking about her December 3rd memo. Where is it? Okay, well, it's right here. You have the complete record. That's what I'm suggesting. And that's, to piecemeal it out, I think it would be really inconsistent. And I think, what are they doing here? Because you're excluding certain documents that were all part of the permanent record. So anyhow, no.
Okay, I'll come back to my other question.
Yes, the city does have an objection, as reflected in my letter to Mr. Schock and Mr. Stevens, Mr. Preston. The issue isn't so much with the accuracy of whatever transcripts are being produced. The issue is with the fact that the statements, any statements, not called statements, not testimony, the statements made in proceedings before the Planning Commission and City Council were not under oath. Mr. Schock started out this proceeding tonight stating that witnesses would testify under oath. The MPC provides that at a zoning hearing board hearing, witnesses testify under oath. None of these statements were made under oath. We're essentially importing unsworn statements into this proceeding where testimony needs to be taken under oath. It does need to be sworn. I think on that basis alone, you can exclude those transcripts. It's not, we don't even get to the issue of relevance. We get to the issue of competency. One of the elements of competency is that the witness understands the oath that one takes when one testifies. So because that wasn't done at Planning Commission meetings or at City Council meetings, we cannot admit those transcripts. In addition, Mr. Stevens makes reference to the fact that the city, that as I said in my letter to Mr. Schock, I was not there, or an attorney from the city solicitor's office was not there. That's not a minor detail. It's not so much that no one was there, it's that the city isn't a party in those proceedings. The big issue here is with the substantive validity. That's what the challenge is tonight, to the zoning ordinance amendment, which was enacted by City Council. And let's keep in mind, when this matter is before City Council, there is no ordinance. I'm here defending the validity of an ordinance. How can we defend something that hasn't even been enacted yet, which is what the situation was when this matter was before City Council. There's nothing to defend, ergo, we're in a totally separate or totally distinct situation here, where the issues are very different. I'm here defending the validity of an ordinance that wasn't even enacted when these transcripts were made, or, you know, when the matters reflected in those transcripts occurred. So we're in a different situation here. Finally, Mr. Stevens kind of leaves out a lot of the MPC when he talks about how formal rules of evidence don't apply in zoning hearing board hearings. He leaves out the fact that, and it's in that same subsection 6, formal rules of evidence shall not apply, but irrelevant, immaterial, or unduly repetitious evidence may be excluded. In other words, Mr. Preston and I can make objections to the evidence presented by Mr. Stevens, and this board can sustain the objection and exclude it. To say that the formal rules of evidence don't apply doesn't mean that everything goes out the window and everything comes in. There are standards of evidence here, just not as stringent as those that might apply in common pleas court. So I do have the ability to object, an ability that I did not have at the Planning Commission meeting, at City Council meeting, when the city is not a litigating party to the proceeding. Finally, to wrap this up, again, and Mr. Stevens omitted this from his presentation, subsection 5 of section 908 of the MPC indicates that the party shall have the right to be represented by counsel and shall be afforded the opportunity to respond and present evidence and argument and cross-examine adverse witnesses on all relevant issues. And I think Mr. Stevens, in fact, said, he acknowledged that at City Council meetings and at Planning Commission meetings, we don't have cross-examination. That's not the kind of proceeding that is. Whereas here, we do, pursuant to statute, I have the right to cross-examine any adverse witnesses, a right that I was not afforded and the city was not afforded at the prior proceedings. So I would say for all those reasons, these transcripts cannot come into the record tonight. And I guess with respect to the separate issue of the exhibits, first, I'm not really sure I understand that, but I will say this. Mr. Spurk is the solicitor for Bethlehem City Council. I am not, to be clear, I am the solicitor for the city. I am here, even though I'm defending an ordinance passed by council, because it is the duty of the city solicitor's office to defend the validity of city ordinances when they are challenged. So that is why I'm here, and I'm obviously defending an ordinance after it's been enacted. Mr. Spurk, as I understand it, I don't think I was at those proceedings, but was advising council, as he does at every council meeting. And with respect to whatever was presented at City Council, as Mr. Stevens knows, in the procedural validity challenge, now pending in common pleas court, I have vigorously opposed the introduction of everything under the sun that was attempted to be quote-unquote introduced at the City Council meeting, because, as I indicated in my filing to common pleas court, that evidence was not presented under oath. We don't really have a record of it being accepted. Essentially, the appellants here, I guess objectors there, just hand up a bunch of documents to council members. It's not like they're formally passed on and admitted to evidence, or there's an opportunity to object or anything like that. So we don't know what was considered. We have no real record of what was considered. When I produced and compiled and produced a certified record that I submitted for the appeal to the procedural challenge, I did not include all those exhibits, as Mr. Stevens knows. He objected to my decision not to exclude, or not to include those exhibits, which was not really ruled upon by Judge Corey, who just scheduled this matter for a non-jury trial. So Mr. Stevens has taken this position before. I'm opposed to the position he's taken with respect to the exhibits. If he has them here, what I would suggest is that he have a witness who can authenticate them and present them tonight for the board. Thank you.
Mr. Deschler, isn't what he's suggesting, though, something akin to legislative, the legislative history of how a matter came before the ultimate determination on the ordinance? So it was what happened at, let's say, committee meetings or those kinds of things, which are not under oath necessarily. But isn't it part of that legislative history?
I understand the point. I suppose I would agree with that. I suppose my argument or response would be that that is still not admissible at a zoning hearing board hearing where all evidence, and Mr. Stevens has represented that he intends to introduce these statements as evidence, where evidence must be taken under oath. So I think it's not just the deliberations that he's presenting of council members and planning commission members. He's presenting obviously as well the statements made by people who spoke at those meetings. And because that's the nature of the transcripts and what Mr. Stevens intends them to be used for, I do think they need to be introduced under oath. But I suppose in the same way that, I mean, for example, like Senate committee hearings, they are under oath. Witnesses speak under oath. But in terms of the deliberation of legislative bodies, which I don't believe are under oath, I would agree. It's kind of like legislative history. I don't think it's relevant to the issue before this body, which is whether the text of this zoning ordinance amendment and its operative effect on the city's zoning scheme is substantively defective. So I don't think it's relevant to that issue, to a substantive validity challenge. And before we get to that point, I don't think that sort of evidence, the legislative history, is relevant, and I don't think it's evidence that's presented under oath.
Thank you.
Go ahead.
I really would like to say something here, because I'm kind of struck by the irony of this request. We're here purportedly because there's been a violation of due process that the applicants would like to see corrected. Now, as Mr. Deschler said, the MPC does state that the party shall have the right to be represented by counsel, shall be afforded the opportunity to respond and present evidence, an argument, and cross-examine adverse witnesses on all relevant issues. And as Attorney Stevens has conceded, the transcript of the hearings that he wants to put in, there is no right to cross-examine. The witnesses weren't sworn, and we have essentially unreliable, I wouldn't even call it testimony at this point. Is there a reason to bring them in here? Perhaps. And the reason depends on what's the purpose of the offer. The purpose of the offer is to show that, hey, they had hearings, they did, and this is essentially when they had them. That would be a legitimate purpose, and we could handle that by a stipulation. But that's not the purpose of the offer. The purpose of the offer is to establish the truth of the matter asserted in that testimony, in that unsworn testimony. That's really the only purpose to bring those in. And if you follow the pleadings and you've read the application to the zoning hearing board, what immediately becomes obvious is that where we're going here is we're seeking to investigate the legislative motives and methodology that go into adopting, in this case, this particular legislation. And I think that's a wildly irresponsible undertaking for a zoning hearing board. To examine the motives and methods in adopting the ordinance, that's not part of the substantive validity challenge. There are no cases that include that. My colleague's not going to find any, because that's not something that the judiciary engages in. What the courts do, and essentially you're acting as a court, is you have to focus on the amendment itself. And the amendment stands or falls on its own terms. It doesn't matter if there was an impure motive in adopting a piece of legislation. You don't strike it because it's an impure motive. You don't say, I don't like Ted Cruz, we're going to get rid of that. It just doesn't work that way. They adopt it, you examine the legislation, and it's either, it either stands or falls on its face. So really what's important here is what occurred as of the effective date and thereafter. Not reams of unsworn testimony that occurred at a city council meeting where different people were expressing different views that now needs to be imported into this hearing without any right to cross-examination, to cross-examine the witnesses, any way to test the veracity of what they're saying, and simply have it embedded here for the truth of the matter asserted. I think that's, I think it's dangerous. That in and of itself, I think, is violative of due process. But I also think to embark on an investigation of the legislative motives that went into this is wrong. And I think it's beyond the scope of these hearings. I don't think the judiciary should be engaging in that. I don't think they do engage in that. The ordinance speaks for itself, and the applicants can make their case just as everyone else who's ever presented a substantive validity challenge to a zoning hearing board or to a court.